Hi, welcome to the third and final part of our video lecture series for Module 3. In the previous video, we were able to answer the question of what does the phrase deemed owners mean. We said that the Supreme Court construed this to mean that the law does not automatically confer ownership over the tenants, the covered tenant farmers of covered lands. Rather, it's a recognition that they are qualified beneficiaries, that the land is covered, and that uh, the necessary things have been identified, and that it recognizes merely inchoate rights under the law. These are not yet real rights that may be enjoyed and exercised by the tenant farm workers until after compliance with the requirements and general procedure that are undertaken under the law. All right. Uh, and we have discussed also in a general, very general sense, since we are not discussing the technicalities in those procedures. Okay, but we were able to identify uh, the general procedure of how uh, a tenant farmer, covered tenant farmer, is able to progress from an inchoate right to a real right. All right. Now, in relation to the general procedure, we've made mention of some documents. We've made mention of some, in fact, two important documents that are issued in relation to the implementation of this law of PD 27. And so, in this portion of the discussion, we will make a brief lang na comparison of these two, a distinction of these two documents. And our distinction, our comparison is guided by the Supreme Court uh, in the case of De La Cruz versus Domingo et al. In 2017. Now, in this case, the court was called to distinguish and to clarify what's the difference between an emancipation patent and a certificate of land transfer, because admittedly the nomenclature, diba? Certificate of land transfer na good. So it's kind of misleading, it's kind of confusing to some, and in order to clarify this, the court had to distinguish them in this case, right? So we will do the distinction, the comparison per category, all right, per category, for in order for our discussion to be guided accordingly. All right. So firstly, we distinguish a certificate of land transfer from an emancipation patent as to the stage when they are issued. Okay? At what stage of the whole general procedure in relation to PD 27 uh, would a CLT and an EP be issued? All right. As discussed in the previous video, as uh, alluded to in that video, this certificate of land transfer, it does not uh, operate to be the basis for the transfer. No? This certificate of land transfer is just a document that is issued in the preparatory stage of the transfer. Meaning, in this stage, all the preliminary na mga things must have been identified first. And so, certificate of land transfer, that is a preparatory document. It's not yet a basis for the transfer. While the emancipation patent, that's issued in the conclusion of the conclusion stage of the transfer, because it is the last document that is issued. All right. And this is the basis now for the transfer. The emancipation patent, as the term suggests now, this is the document which now grants rights, grants emancipation, okay, of the farmer, of the tiller, right? And therefore, emancipation patent that is issued at the conclusion stage of the transfer. Now, as to requirements, what are the requirements before a CLT and an EP are issued? All right. Now, since a certificate of land transfer is issued in the preparatory stage uh, of the procedure, then a CLT requires that all those mga preparatory na mga things have been complied with. What are the preparatory matters that needed to be complied with? First, there has to be identification of the land, identification of the covered land, identification of the covered beneficiary farmer, and identification of the boundaries of the land. No? And it is only after all these na mga preparatory matters, preparatory things that have been complied with, can a certificate of certificate of land transfer rather, be issued. All right? The CLT, because it is a preparatory document issued in a preparatory stage, it requires therefore that all preparatory matters must have been complied with. Right? In contrast, since emancipation patent is issued at the conclusion stage of the procedure, it therefore requires, since now this emancipation patent is the basis for transfer of ownership, it then therefore requires that there has already been, number one, valuation of the land, and more importantly, not just valuation, but also the payment of that valuation constituting just compensation. Because in order for the principles of eminent domain to not be violated, there must have been payment of just compensation before a private property is taken. All right, and therefore, in this issuance of emancipation patent, all right, as a condition sine qua non, there must be, number one, valuation, and more importantly, number two, payment of just compensation. All right. If these two requirements have been complied with, then an emancipation patent may be, in generally speaking, be issued. All right. That's as to requirements. And then as to effects. As to effects, all right, as we've said, since a certificate of land transfer, it's not an evidence of title, meaning it's issued in the preparatory stage, and therefore it's not an evidence of title. It merely signifies that the land is covered, the beneficiary is covered, they have been identified pursuant to PD 27, and that the boundaries have been identified. All right, and that these mga beneficiaries have inchoate rights, not yet real rights, but merely inchoate rights. Because lagi, under a certificate of land transfer, it is a preparatory document. Everything is still under preparation. All right? But in emancipation patent, because an emancipation patent is the final document, the concluding document that evidences transfer of ownership from the landowner to the farmer, to the farmer beneficiary. This emancipation patent therefore serves as the valid basis for the issuance of a certificate of title. No? Note, this emancipation patent is not the certificate of title. All right? This emancipation patent, just like your mga homestead patent, mga sales patent, which you will be discussing in your land titles and deeds, these kinds of documents will have to be registered in the Register of Deeds, and they become the basis for the issuance of a certificate of title, or the issuance specifically to the landowner, to the new owner, a certificate, a duplicate certificate of title. All right. Uh, because this emancipation patent conclusively entitles the beneficiary with ownership, having because the payment of just compensation have been done. No, this emancipation patent is the document that should be registered with the Register of Deeds for purposes of the issuance of certificate of title. That certificate of land transfer, that will not have to be registered. That cannot be the basis for the issuance of certificate of title. All right. So only then, therefore, can a person be issued a certificate of title if na-issuehan na siya og emancipation patent. All right? Because this emancipation patent, this conclusively vests ownership on the beneficiary, on the farmer beneficiary, over the identified family size farm. Again, we repeat, ang area of the family size farm will have to vary depending on whether it is non-irrigated or irrigated. All right? Now let's go to another matter concerning, which is a very important matter concerning PD27. Now, since PD27, as I've said in the first video, since PD27 essentially adopts the notion, the concept of transfer of ownership from the landowner to the covered na mga beneficiary, it is necessary for this law to somehow create a balance. Of course, depriving one of his or her property would be to an extent prejudicial to a person. Of course, to an extent, that person deprived with the property is prejudice. But in order to balance the interests, because this deprivation of property is not for some private use, it's not for some benefit of like a few people. This deprivation is for common good, right? For social justice, all right? And so, in order to balance the demands of social justice, of common good, of society, the good of society, all right, and the interests of the affected citizens, meaning affected landholders, whose lands may be deprived from them, all right, the law must strike a balance, and this balance is sought to be approximated by including this provision, okay, or provisions on retention rights. Okay, now retention rights are placed in this law because, as again, this law implements agrarian reform by deprivation of property, deprivation of ownership. Right? In RA 3844 and in the tenancy laws, there's no such thing as retention rights because the primary mode of their primary mode of implementing agrarian reform is not through transfer of ownership. just restriction on the ownership, restriction on the conduct, on the arrangements of the parties. All right, but here, since it involves acquisition of land and redistribution of lands, there has to be some form of protection. There has to be some form of a mitigation to the effects of agrarian reform. All right. Uh, in Presidential Decree number 27, it says here that in all cases, okay, the landowner may retain an area of not more than 7 hectares if such landowner is cultivating the area or will now cultivate it. Right? Now, I highlighted here first the area of the retention. All right? The area of the retention is at maximum 7 hectares only. All right? Uh, it may be less than 7 hectares should the landowner opt to. But the maximum under the law is 7 hectares. If the landowner wants to retain that maximum of 7 hectares. All right. Now, as I said, this concept of retention rights, it's a form of it's the way of the law to approximate the balance of rights between the landowner and the farmers or the beneficiaries. In fact, in the case of Digan versus Malines in 2017, the court characterized retention rights as the mechanism of the law to mitigate the effects of the compulsory land acquisition. No? In fact, the court said it is to strike a balance between the rights of the landowner and the tenant. All right? Because the by virtue of retention rights, by virtue of the availment of retention rights, the landowner is not deprived of all the land holdings. Right? The landowner is deprived only of a part or a huge part of the land holding, and he or she is given the opportunity, the chance by the law to retain some of the land holding, to retain a portion of the land holding, not more than 7 hectares of land. All right? Now, in order to exercise the retention rights, now under the rules, I recognize and admit that there have been so many or several na mga memorandum circulars and letters of instructions in relation to the exercise of retention rights. But for purposes of our discussion in this course, we will not be diving so much into those technicalities. Too technical na for us. So what we will be discussing would be just these general na mga requisites in order for the landowner to be able to exercise the retention rights under the law. All right? So, if a landowner has a land holding that is covered by PD 27, that landowner will have the right of retention. Will have the chance to retain a portion of the land not more than 7 hectares. Alright? Now, in order to be able to exercise these retention rights, the landowner must do 2 things. First, he must express his intention to avail of the right. Because it's a right, it may be waived. And in this case, it may be waived if not availed of. If not availed of through the recognized means. No? The recognized means of exercising the right of retention is to file an application. File an application with the DAR, all right, expressing the intention of the landowner, right, to retain a portion of the covered land. Okay, and since the whole program for Operation Land Transfer, all right, has a timeline. The administrative nga mga government agencies imposed a deadline. And the deadline was on 27th of August 1985. All right? Such that not only must a landowner exercise the right of retention by expressing his or her intention in an application, that application must also be filed on or before the deadline. The deadline being 27th of August 1985. Now, after the deadline, okay, as a general rule, although I understand that there are exceptions, all right, but as a general rule, under the mga rules before CARP, okay, the landowner is considered to have waived his or her right, right, to retention rights. All right. If the landowner before CARP, okay, and then if the landowner failed to apply for retention rights on or before the deadline on 27th of August 1985, the prevailing notion was that the right under PD 27, the retention right under PD 27, is now waived. Now, if for example, now since there is now RA 6657 and RA 6657 also has rules on retention rights, what happens now to those mga landowners who failed to apply for retention rights on or before the deadline on 27th of August 1985? Now, as we shall be discussing in RA 6657 in Module 4, no, we will see that the court seems to favor, no, the retention rights, as seems to favor the construction that within RA 6657, within the framework of RA 6657, those landowners whose lands were covered by PD 27 but failed to submit the application on the deadline may still be entitled to retention rights. But retention rights not anymore under PD 27, which is 7 hectares, but retention rights under RA 6657, which is merely 5 hectares. Okay, we will be discussing that in more detail in Module 4. But as of now, no, in this module, in order to exercise retention rights, as a rule, in order to exercise retention rights, firstly, there must be an application, okay, expressing the intention of the exercise of retention rights, and this application must have been filed on or before the deadline on the 27th of August 1985. All right. Now, what are the requirements for the exercise of retention rights? How may a landowner be able to exercise the retention rights? What are the basis for his retention rights? Now, according to the law, a landowner of a covered land may be able to retain not more than 7 hectares of the land holding if he or she cultivates the land or will now cultivate the land. All right. Now, it is therefore recognized that there are three, uh, either no any of the three may be considered as a basis for the exercise of the right of retention. All right. Number one, there's actual direct cultivation. All right. If there's actual direct cultivation, then the landowner may be able to exercise retention rights. But also, no, under mga pertinent rules, not only actual direct cultivation are recognized, there can also be instances of actual but not direct, in fact, indirect lang siya nga cultivation by the landowner. Meaning, in this scenario, in this circumstance, it's not the landowner himself or herself who actually cultivates. No? There are mga authorized representatives, siguro mga heirs, siguro mga son and daughter of the kaning of the owner. All right. So such that here there is actual cultivation, but not directly by the landowner, but through other persons, uh, and therefore it's an actual but indirect cultivation. But here, no, there's also another basis for the exercise of right of retention. It's not just actual cultivation that is recognized, but also intended cultivation, because the law states that uh, the landowner may be able to retain not more than 7 hectares of the land if he or she is cultivating or will now cultivate the land. And therefore, if there is intended cultivation of the land by the landowner may say, oh, in this portion, in this area, I have intended cultivation. I will now cultivate this area, and therefore I will exercise the right of retention. Any of these three may suffice as basis for the exercise of right of retention, right? And this also is viewed as one of the loopholes, one of the weaknesses of the law, because intended cultivation may easily be proven. Also, actual indirect cultivation may be used as a tool to expand the whole retention rights. It may be that this landowner will uh, will do a somehow a subdivision. We call that chop method or system, where the whole land holding is chopped into smaller pieces of land, but still still vast, and then they are they are they make it appear that the relatively smaller lands are owned by different persons, such that there may be 7 hectares here in this portion, and another 7 hectares in this portion, another 7 hectares in that portion, which uh, circumvents this whole uh, maximum retention rights of 7 hectares. But then again, that's how the law works, and that's based on the provisions and principles of the law. All right. Now, in relation to the question of to the matter of retention rights, okay, provided, all right, there's this retention rights. There is a valid basis for retention rights. There, we know already the requirements for the exercise of the right of retention. Then the next question that we want to ask is, who can exercise the right of retention? Of course, we say in the law there is a clear definition, a clear identification that the landowner, okay, it is the landowner who has the right of retention, right? But then, why do we ask who can exercise the right of retention? Okay, consider uh, this fact, this case of Saginsin versus Liban in 2016. All right. Now there are three personalities involved. All right. We have the original owner of the land. All right. Uh, who subsequently died, of course. But before he was able, before he died, he was able to sell the property, an agricultural land primarily devoted to rice and corn. Okay, this original owner was able to sell that to a buyer, no? But the buyer bought it in 1972, right? Now, since the original owner is already dead, then we can only look now to his heirs of the original owner, no? So there are, obviously, the original landowner, had he been alive, there's no question as to which of them has the right to exercise retention rights. All right. But since the original owner, is already dead, there's a question: who between the current owner, no, the buyer after 1972, and the heirs of the original owner can exercise the right of retention? All right. In this case of Saginsin versus Liban, the court had to adjudicate the validity of the ownership of this buyer in 1972. The court, in order to resolve the matter, firstly examined whether this current owner had the right to exercise retention rights. Right? Unfortunately, the court said, in this case, the buyer who bought the land in after 1972, after PD 27 took effect, that buyer cannot exercise the right of retention. The buyer cannot exercise the right of retention because, number one, according to the court, he's not the owner in this case. He's not the owner in this case because the sale is in violation of the law. All right? The provisions of PD 27 prohibits owners of covered na mga agricultural lands from selling their agricultural lands primarily devoted to rice and corn. All right? And therefore, this sale, which involves a covered land, meaning it involves a private agricultural land which is primarily devoted to rice and corn, is in violation of the law. It's in violation of PD 27. And because the sale is in violation of that law of PD 27, the sale is void. And because the sale is void, the buyer, or this purported buyer, is not considered as a landowner. All right? And more importantly, according to the court, this buyer is not a buyer in good faith. Meaning, this buyer did not exercise due diligence in the acquisition of the land. And because the buyer is not a buyer in good faith, the buyer cannot shield himself from the illegality, from the nullity of the sale. All right? Because according to the court, the fact that the land is tenanted could have been easily ascertained and verified by this buyer by taking steps in due diligence, by examining the physical status of the land, etc., etc. But all these were not done by the buyer, and therefore the buyer failed to exercise due diligence. And because the buyer failed to exercise due diligence, the buyer is not a good faith buyer, meaning this buyer cannot shield himself or herself from the patent nullity of the sale. And therefore, because the sale is patently null and void, this buyer cannot be considered as a landowner. This buyer cannot be considered as landowner for purposes of exercising the right of retention. Alright? According to the court, if this buyer cannot exercise the right of retention, then there must be someone else who would have the ability to exercise the right of retention. Okay? And in this case, according to the court, since the original landowner is now dead, then who will succeed in the place of the landowner? It is the heirs. Okay? According to the court, in this case of Saginsin versus Liban, because there are already prior manggod nga mga decision from the office of the president and from the DAR saying that the heirs, they did not have the right to exercise the retention rights because they are no longer the owners. Right? It was already transferred. But according to the court, since the sale to that person, to that buyer, is considered as void, okay, and therefore that person, that buyer, cannot exercise the retention rights. All right, the heirs now, okay, simply because, and also in addition, the heirs were not given the chance to prove the intention of the intention of the landowner, original landowner, to retain the portion of the land. According to the court here, the heirs may exercise the original landowner's right to retention if, now there's a condition, if they can prove that the decedent had no knowledge of the coverage of the land. Alright? If they can prove that there is no knowledge of such coverage, and because there's no knowledge, there was no opportunity for the original landowner to avail of the retention rights. Okay? And therefore, if the heirs are able to prove that the decedent had no knowledge of this coverage, then they are given the chance now to prove or to express the intention to exercise the right. Since the original owner did not have the opportunity to exercise retention rights. Alright? Because he did not know anything about the coverage at that time. Alright? But had he known, then that would be a different story. Okay? But in this case, since there is no showing in the evidence presented before the Supreme Court that the landowner's heirs were given the chance to prove that there's intention to exercise the right. Alright? So according to the court here, the heirs, they may exercise the right of retention if they can prove this thing. If they can prove that the decedent had no knowledge of the coverage over the subject property, then these heirs may be able to express their intent, since now they now succeed to the place of the original landowner. Now it is now the heirs who have the right, who have the privilege to express their intent. Okay? To express their intent to to exercise retention rights. All right? It's not the buyer, because the buyer because the sale was void and the buyer was not a buyer in good faith, and therefore it's the heirs, according to this case of Saginsin versus Liban. It's the heirs who have the right to retention if they can prove that the original landowner, the decedent, had no knowledge of the coverage, and therefore now they are given the chance, or they will be given a chance to prove or to express their intent to avail of retention rights. Right? Now that's for retention rights. Now let's go to another matter, another limitation on that is contained in PD 27. Now there is a paragraph in PD 27 which prohibits transfers, no, of lands that are acquired by virtue of the provisions of PD 27. Specifically, this provision stating that title to land acquired pursuant to this decree or the land reform program of the government shall not be transferable, right? Except by hereditary succession or to the government. So this prohibition against transfer is of course, it's not absolute. All right. This prohibition against transfer generally, as a rule, prohibits transfers of all lands that are acquired pursuant to PD 27. All right. But since it is not absolute, there are exceptions. First exception would be hereditary succession. Now that's passing the land from the decedent to the heirs. All right. It's a recognized exception because there's no farmer beneficiary who will live forever. All right. There will come a time that a farmer beneficiary will have to pass from this life and leave all the material things to his or her heirs. All right, and that scenario is covered by our succession laws, covered by hereditary succession, and there's no control. I mean, the farmer beneficiaries, they have no control over that. In fact, it's a recognized natural occurrence that farmer beneficiaries, like all men do, they die. Okay, and therefore they have to leave their properties behind to their heirs. And so this is a necessary exception. Okay, because it would be absurd. It would be absurd if even hereditary succession is not allowed under the law. All right, it would be absurd because there will be a scenario where the property will have no owner simply because the owner died. And and as you will learn later on in your succession class, the policy of the state is to avoid properties that are ownerless, meaning to avoid a scenario where properties do not have an owner. That is why under our succession laws, under succession laws, ownership over the properties of the decedent are passed to the heirs at the moment of death. Meaning, at the moment of death, whenever that is, the rights over the properties of the decedent will automatically be given or be transferred to the heirs. Okay, and then there is no break in the ownership. There's no hiatus. There's no gap in the ownership. Okay, because at the moment of death, the time the decedent breathed his or her last breath, the ownership under the law over the properties are transferred to the heirs. All right, so it's a necessary exception. So that's number one. And second exception would be transfer back to the government. If the landowner, if the beneficiary realizes that perhaps there's a better option than this, perhaps the beneficiary cannot continue or opts to not continue to be the owner of the land, the farmer beneficiary may sell back the property to the government. So those are the only two recognized exceptions to this prohibition against transfer. So as a rule, we reiterate, as a rule, title to land that are acquired by virtue of Presidential Decree number 27 are not transferable. There is a prohibition against transfer. But there are two recognized exceptions. Number one, hereditary succession. And number two, transfer back to the government. Right? What's the reason? What's the reason for this? Okay, in the case of Estolas versus Mabalot, according to the court here, the rationale for the emancipation is to give the beneficiaries the rights to possess, to cultivate, and enjoy the land holdings for themselves as owners, as owner cultivators. Okay? These rights were granted by the government to them, okay? Because they are tillers in that covered land and because they are considered as covered ng mga beneficiaries. Thus, in order to ensure that all these mga ideals of the law, meaning kaning possession, cultivation, and enjoyment as owners, okay, and the continuous possession and enjoyment of the property, there is a restriction imposed so that these mga beneficiaries would not be tempted to transfer to any person for money, for some other mga consideration, and then go back to the state where before they were awarded with the land. All right, there is a prohibition placed under that, under the law. There is a prohibition that they may not validly transfer that, except for the two recognized mga instances. Number one, hereditary succession. In fact, this recognition on hereditary succession that is in line with the ideals of the law, meaning continuous possession and enjoyment. Because if the landowner is dead, no, there's no more there's no one else who can enjoy and possess the property except the heirs. Okay, and to recognize and to give more life to that ideal nga na ay continuous possession and enjoyment, it's a necessary exception therefore to recognize this hereditary succession. And of course, recognize also to exception is transfer back to the government, because the government may be able to give it the land, may be able to maybe redistributed, retransferred to other beneficiaries covered under the Agrarian Reform Program of the government. All right. Now, since just like RA 3844, okay, kaning PD 27, there is already a subsequent law, no, passed after this one, right? Since there's a law passed after this one, we can therefore ask, is this law still effective? Is this law still being implemented? Has this been repealed? What's the legal status of PD 27, right? And for this purpose, we quote Section 75 of RA 6657. Now, here it is clear, the provision of RA 6657, it is clear that the intention of the lawmakers is not to repeal PD27. It's not to supersede PD27. In fact, according to this provision, the provisions of PD27 which are not inconsistent with the Act will have suppletory effect, meaning it can still be effective, all right, but not anymore in a primary manner, but in a supplemental manner, as long as the provisions of PD27 are not inconsistent with RA 6657. All right, and the provisions of PD27 are not inconsistent with the act of with RA 6657 because PD27 is limited in character. All right, and what RA 6657 does is it expands, okay, the coverage of the law, such that PD27, we can view it from the perspective that 6657 expands PD27. That's why RA 6657 is called comprehensive. Okay, one of the factors making it comprehensive is that it does not anymore limit its application to mga private agricultural lands that are primarily devoted to rice and corn. All right. So, one example, one scenario where PD27 may be able to suppletorily apply even with the passage of RA 6657 is when, for example, in this scenario, okay, there is a land that is covered under PD27, and then subsequently RA 6657 takes effect. All right? Although covered na siya sa PD27, its whole process was not yet complete. All right? Na overtake na lang sa passage sa RA 6657. And then now we come to the point of yes, we'll have to pay na just compensation. Okay? But the question is, on what law do we base our just compensation, our valuation of just compensation? Do we base it on PD27, which was the law effective when it was covered, or do we base it on RA 6657, which is now the new law on agrarian reform? No? Okay, now just to illustrate lang the difference between PD27 and RA 6657, more specifically in as to the factors in just compensation, we illustrate this by identifying unsay basis of just compensation in PD27 and RA 6657. Now, under PD27, the basis for just compensation is just one. In fact, it's rather simplistic because the computation, although we will not be computing just compensation, but the basis for the just compensation, for the valuation and therefore the just compensation, if the law to be applied is is PD27, is simply 2.5 times the average of 3 normal crop years immediately preceding the promulgation of the decree. Meaning, the average income, average na mga product yield of 3 normal crop years immediately preceding the promulgation of the decree. Meaning, that's just one, usa lang ka basis, right? Under PD27. But under RA 6657, the bases are several, and therefore the framework for the determination of valuation and just compensation is much more complex. Complex because there are several factors. Example, cost of acquisition, current benchmark nga value, meaning the same properties in the same nga mga location, all right, and the actual use, the actual income, etc. There are many nga mga factors which makes the framework under RA 6657 much more complex than PD 27, which is just, diba, murag one-dimensional lang siya, kanalang average income of 3 normal crop years immediately preceding the promulgation of the decree. Right? So there's a question therefore, no? If, for example, a land is covered by PD 27, in fact, there have already been steps taken towards the acquisition of the land under PD 27, but then the whole process was overtaken by the passage of RA 6657. Now, at the time of the valuation of the land, where do we base the valuation? RA 6657 or PD 27? Alright? Now, the court said in the case of Land Bank versus Heirs of Cruz in 2008, alright, that in such a case where the process of agrarian reform is still incomplete, and then the whole process was overtaken by the passage of RA 6657, the valuation must now be based mainly on RA 6657. Alright? Because under RA 6657, there are several na mga factors. As I said, the framework for the valuation is much more complex. And therefore, according to the court, this more complex na basis for valuation is more, it's in the interest of the landowner. All right, it grants more protection to the landowner because of the complex framework of just compensation. There is a greater chance to arrive at a full and meaningful na just compensation. I mean, full and complete na price corresponding to the land, which, according to the court, may be considered as just compensation. Note here, according to the court, the valuation will not be solely based on RA 6657. It is mainly based on RA 6657, but the provision on PD 27, specifically on just compensation, may apply suppletorily, meaning that factor in PD 27 may still be applied, but it's not the only factor to be applied. It must be in addition, okay, to the factors under RA 6657. Kaning PD 27 nga factor may also be considered because PD 27 applies also suppletorily, right? And so that ends our video lecture series for Module 3 on Tenant Emancipation Decree. Alright? For our next module, for our next video lecture series, we will now go into the current nga agrarian reform framework, which is the Comprehensive Agrarian Reform Law, or CARL, as amended. Thank you for your attention. Thank you for viewing our video lecture series, and see you in the next module. Bye!